So what do you do when you have a client that calls and tells you essentially that they've done everything they can do wrong in the case? And that not only have they done it wrong, they've done it wrong for the past several months in a row. They've admitted what they've done wrong to the judge. They've basically told the judge what their plans are, and those plans end up being something that's going to help them lose custody of a child. How do you take that case, run with it, and win? That's the focus of the next Legal Smith Unleashed. We had a client call recently, as it typically happens in my line of work. It's mom versus dad. The parties were together. They had a beautiful baby. The baby's 4 years old, going to be starting school in the fall. And the parties split up, decided they needed a formal custody order, and took the case to court. Now, the parties decided, as a lot of people do, we can do this ourselves. We don't need attorneys on this. We can just figure it out. And so what a lot of people don't understand, especially here in Las Vegas, is that the Las Vegas court system is very busy. There's a lot of people that come here to Las Vegas and they find their one true love, and they do what one does with their one true love, and they end up having a offspring from that one true love, and then decide that that one true love is not the person they want to be with. That happens an awful lot. And so as a result, our family court system here is extremely busy. And so when you file a case in the family court, you're not necessarily going to be done in a week. Okay, it may take 6 months. It may take a year to get through the whole system, depending on what judge you get and what kind of issues you and the other party have. Typically speaking, you're going to file a complaint. There's going to be an answer. There's going to be a answer to counterclaim. And you get assigned a judge, and then you go in front of the judge once, twice, maybe 3 times, and then trial. And that's the path that these folks were on. Except mom, who is the party that called my office, decided in the middle of her custody case that she really didn't want to live in Las Vegas anymore. She doesn't like Las Vegas. Las Vegas is not the town for her. It's not the town for her child. So she goes to dad and says, "Hey, Dad, wouldn't it be great if we moved? You know, we're not together anymore, but that's okay. Well, you and I are going to move, and we'll move to the same town. Any old town that's not Las Vegas, let's do it." And Dad says, that's interesting, because we had filed for joint custody, and Mom is the party that makes a lot less money. Dad's making a whole lot of money, and he's going to be the party that ends up paying child support. Now, that's all well and good, but for some reason, there are those people out there, call me crazy, I don't know why, they don't like paying child support, okay? And Dad says, I'm going to end up paying Mom a lot of child support because I make, $150,000 a year. Mom makes about $40,000 a year, and as a result, I'm going to end up paying her a lot of money in child support. Let's see where this goes. So Mom asked Dad if he'd be willing to move somewhere, and he says yes. He says, "I've got family down in Mississippi." Mom says, "I love Mississippi. Let's go." And Dad says, "Okay, well, I got some stuff to wrap up here, but if you want to move, why don't you move down there, and then I will follow you. And, you know what might be fun? I'll keep the kid here, and you move, get yourself all set up, and then we'll start on this custody exchange thing." Mom thinks that's the greatest idea in the world. She came up with it after all. And so Mom ends up moving probably about a week before her second to last hearing in the case. And she moves. She's now down in Mississippi. And they go in front of the judge, and Mom tells the judge, hey, judge, you want to hear something really fun? I've moved out of state to Mississippi, and Dad and the child are still there, and I think it would be a great thing if me and Dad had joint physical custody, which is approximately 50-50 custody of our child who's about to start school in August, and make it happen. And the judge looks at Mom and says, that's never going to happen. I'm never going to do that. How are we going to ever do that if you've got a child going to school in August? She's going to be starting kindergarten, and you need to be probably in the same state, maybe close by where Dad's living. And Mom says, yeah, but I don't want to live in Las Vegas. In fact, I'm never coming back. And the judge says, well, that's really too bad for you. Because that means Dad's going to have primary custody, and you, Mom, are going to owe him child support. Now, look, maybe you've heard stories, maybe you haven't. There's a lot of guys out there that don't like paying child support. Okay, there are some guys that don't mind. Hey, they say, this is my child. I'll pay what I need to pay. I'm a stand-up guy. I'll do what I need to do. But there are a lot of guys that say, hey, I had a baby with this baby mama, and she's not the girl for me anymore. And yes, I have a child, but if I give her money for child support, she's just going to spend it on makeup. She's just going to spend it on her nails. She's just going to spend it on seeing other dudes. So I don't want to give her child support. Very, very common thought process. And there's a term that we use for guys like that, or that's generally used for guys like that, guys that don't like to pay their child support. They call them, I know you've heard this, deadbeat dads. Okay? Now, you think deadbeat dads are horrible people, and because they don't want to pay their child support. Try having a mom get ordered to pay child support. You have never seen hellfire in the eyes of a woman until you tell her, hey, by the way, there's this guy that you had a baby with, and I know you carried the baby for 9 months. I know your back was hurting. I know you had to push this baby out. It was hard. It was painful. It was something that it was an experience that changed your life. Maybe you never want to even do it again. And now you get to pay Dad child support. You have never seen anger like that. We don't call them deadbeat moms. We only apply that moniker to the dads, right? So Mom gets told that Dad's going to get primary custody and that she's going to get to pay him child support. But as the story goes, the way the law works in Las Vegas, every order that's made in court prior to a trial, unless the parties agree, is a temporary order. So unless the parties agree, we're going to go push it to trial. And that's what the judge did. The judge sets it for trial so that we can come up with some final orders and make it so that Dad has primary custody and Mom gets to pay him child support. That's what's going to happen. And so about 3 weeks prior to trial, Mom calls my office and says, hey, Mr. Smith, here's what I need. I need you to make it so that the judge, number one, doesn't hate me anymore. Number two, doesn't think I'm the worst mom in the world. And number three, doesn't give Dad child support or custody, so I don't have to pay him child support. Go. Okay. Can it even be done? Well, the answer is, if you know what you're doing, you can. So here's where we are. And this is what we've got to figure out when we're attacking a case like the case before us. Who are the players, okay? So the players in this case are Mom and Dad. Fairly simple scenario. They've got a child. What's the backstory? We just went through the backstory. What does the judge know? Okay, here's where we really come into problems sometimes, because in this particular case, again, mom told the judge that she has moved from Las Vegas. She's never coming back, but she wants joint custody across state lines. That's something the judge is going to take notes on. That's something the judge is going to remember. And what else she's going to remember is that mom is extremely dumb, because that can't happen. So now we know that. Who's the judge? Well, in this case, we've got Judge Mastin. Okay, now Judge Mastin, extremely smart judge. She's been on the bench for a while, not necessarily in the judicial capacity the way she is now. She used to be a protective order commissioner, kind of a junior judge that would hear the temporary protective order. She did that for years and years and years. She finally got appointed to be a judge, a full-blown family court judge. She did the custody and divorce cases for a while. She got moved down to abuse and neglect, and now she's back doing the domestic divorces and custody cases. But she knows her stuff. She's been working in a judge-like capacity for at least 20 years. And she's a very smart cookie. So, but we know who we have. And so the next step in this process is, what have you told the judge, and how do we fix it? So in this case, I asked mom, I said, look, if you really want joint custody of this child, you're going to have to do the one thing you don't want to do, which is move back to Las Vegas. Now, in most cases, that's not possible, okay? Because whoever the party is that has moved, they have gotten a new job. They've quit their old job. They've now gotten set up. They've put deposits down on homes. They've created a new life, and to ask them to up and move within weeks of moving the first time just isn't going to happen. But in this particular case, mom had a remote job. She could work anywhere in the world if she wanted to, and she really didn't like Las Vegas, so she just upped and moved with her old job. Kept the same job, moved across the country to Mississippi. And when it came time for me to give her the bad news, she was able to up and move almost immediately back to Las Vegas. So now she's back. What were the parties doing for custody before? Well, Dad had the child full time, but we were able to convince Dad to give Mom custody again and let her start seeing the child, even though they had agreed on this kind of out-of-state visitation plan where Mom's just getting holidays, but she wants to call that 50% of the time. When Mom moved back to town, Dad was welcome to have the break, so he invited Mom back to have 3-4 days a week every week. So that's good news, okay? But the problem is that these parties really don't like each other. Even though those things happened, the parties didn't like each other. And what Dad is telling Mom is, you really blew it in court, and I'm going to get child support from you. And not only am I getting child support, I'm getting back child support for the time that you left, and I'm going to get as much money as I can, so good luck to you. And so, as I look at the story that's unfolding before me and the facts, and knowing Judge Mastin as I do, I know Mom's probably going to lose. But Mom has not hired me to lose. She's hired me to win. So we come up with a plan, and here's the plan, okay? Dad's got Mom dead to rights. We know Mom's moved out of state. The parties went to a court-ordered mediation, and they came up with a parenting plan that essentially was a primary custody plan for Dad with Mom moving out of state. That's an order of the court, and that's there. That's the permanent order, unless something else happens. So what we end up doing is we file a motion to set aside the court order. Because under Las Vegas law, I can set aside any order that's been put into court put in with the court within 6 months. Okay? If there was some kind of mistake, or if there was fraud, or if there's what's called excusable neglect, or in this case, if the court order is void, or if the court order is no longer workable. And so we filed a motion to set aside this order on the basis that mom had agreed to an out-of-state visitation plan because she was living out of state, and now she's back in state. Obviously, the out-of-state visitation plan is no longer necessary, so let's throw it out. And I've got to file this motion with the court. I file it, and then, the court's going to be in now about 2 weeks. My motion hearing is set for a month and a half after the trial. So I've got to get an order shortening time to have the motion heard before the trial or at the time of trial. So that's what we do. We ask the court to expedite the hearing because obviously it would waste the court's time if we went through a whole trial and then we had to come back and hear this motion. And then, mom and dad, dad is, again, making pretty good money. Mom is not making quite as much money. And dad thinks this is the funniest thing because he has basically tricked mom into a scenario where she moved. He kind of told her he was going to follow, but never really planned on following. And now she's going to end up owing him money, especially if she ends up with primary custody, because she already told the judge, hey, my plan is not to be here. So, the judge is already thinking primary custody for dad. So I've got to come up with, look, when you're going to court, there's two basic strategies, okay? I can play the cards that I have, and I can see if the judge is going to rule in my favor or not. Or if I'm losing, are there things that I can throw at the judge or throw at the other side that is going to level the playing field? So dad is asking for child support. Dad's asking for back child support. What can mom ask for monetarily? Well, we come up with some plans. Okay, number one, when the parties split up, mom had the child almost exclusively for about 2 months. So dad's asking for back child support. We can ask for mom to also have back child support, okay? Not only that, but the parties have a little baby. They take the baby to the doctor. Mom's the one that's paid for all the doctor's appointments. So we're going to ask the judge to give mom all of her back medical expenses, okay? Then the pièce de la résistance, okay, is what we call costs of confinement. Now, costs of confinement is all of the medical expenses that mom incurred during the pregnancy. So the question is, did dad ever contribute to those costs of confinement? And mom said, no. I was pregnant, we split up, and he didn't pay for any of it. I had to pay for it all out of pocket. And there's a little-known statute here in Las Vegas that says, and essentially I believe it's because mom has to carry the baby, dad gets to pay all the medical expenses up until the time of birth. So we go back and we ask now for costs of confinement. So now I've got kind of a level playing field, and maybe even a playing field that tips in mom's favor from a financial standpoint. And so I file my papers with the court. I let the court know what we're doing. And dad gets so freaked out. Dad goes out and hires the second best attorney he can find, because mom had already hired me. And so she hires this bulldog attorney to come in and try and he hires this bulldog attorney to come in and try and win the case for him. And so both of us are on the case at the last minute. Dad's attorney calls and says, hey, I'm just coming onto the case. It's now 4 days before trial. why don't we, let's just be nice, okay? Why don't we get together and let's submit a stipulation to the court and say, we don't need a trial in 4 days. We'll just take the trial off calendar, and then you and I can negotiate a reasonable settlement. Well, I happen to know that this particular attorney has never tried to do a reasonable settlement in all the cases I've had against them. Never has this been tried. And I also know the attorney that trained this attorney, and that attorney has never done a reasonable settlement. And so what I'm anticipating is that this attorney is trying to pull the wool over my eyes. Hey, let's take this trial that I don't know what to do about because you've raised all these financial issues. Let's take this trial, take it off calendar for 30 days, and we'll try and negotiate. And then if we really can't, we'll come back to court. And, what I also happen to know, which is why that's never going to happen, is if I take the trial off calendar, the next trial date's not going to be for another 6 or 7 months. My client doesn't have the money to go for another 6 or 7 months. And so we want to get the trial over on Friday. So I told the attorney, look, let me check with my client, see what we can do. And got back to the attorney and said, yeah, I talked to my client. She says no dice. She doesn't want to. I would do it. But the other, my client, she doesn't want to do it. But here's what we can do. Why don't we just settle the case? Here's my offer, okay? Joint custody. Here's the timeshare we want. Dad'll just pay a reasonable child support amount, and I think I can convince Mom to drop all the other financial issues, and maybe everybody just pays their own attorney fees and costs. Opposing counsel gets back to me and says, I don't think so. Here's what we'll do instead. I'll give you joint custody because I think they've been practicing that for the past week or so. But 0 child support. Mom is going to pay Dad all of the back arrears that she owes him, and she gets to provide the health insurance. He's not going to contribute to that at all, and he can pay for her. She can pay for his attorney fees. And I said, no, we're not doing that. And so the attorney gets very angry and shows her true colors and says, look, I knew you weren't going to settle. And I said, well, I knew you weren't really interested in doing a fair deal. So we end up going to trial. And when we go to trial, there is a procedure for trial. You get in front of the court. First and foremost, the court wants to know what exhibits you've agreed to. And in this case, we were each able to agree to most of the exhibits that the other side had. So we agreed to theirs, they agreed to ours, very common, fantastic. What's next? Then we have opening statements. An opening statement is essentially a statement where the attorney tells the court what's going to happen in trial. And so the other attorney gets up and says, because it's their case, hey, judge, Mom moved out of state and she is just, wanting to come in and get a redo. And we don't think you should give her a redo. And she should pay Dad all these fees. And this is why. And she should pay for child support. And that's where we are. And then it's my turn. I got up and I told the judge, look, Judge, this is a very simple case. Mom believed she had a deal with Dad that they were going to move to Mississippi. Mom took the plunge and moved to Mississippi. She asked Dad when he's coming. He reneged on the deal. So she's back. And there's absolutely no reason why these parties can't share joint custody. So if we get custody off the table, now we got to deal with all these financials. And look, it's a lot. I understand it's child support, it's back child support, it's costs of confinement, it's back medical support. Oh, it's just a lot for this court to deal with, Judge. Why don't you send us, why don't you give us your thoughts on what you might want to do? and then maybe I can resolve the case with opposing counsel. Well, the lights go off in the judge's eyes because she doesn't want to have a trial over stupid financial issues. So she says, well, look, I've read through the papers, very well briefed. Thank you very much, Mr. Smith. Thank you very much, Miss Attorney. And I see that, mom has a claim for back child support. Dad has a claim for back child support. If it was me, I might call that a wash. Then dad's asking for all of these other kinds of arrears, but mom's asking for a lot of arrears too. If it was me, I'd probably just call that a wash. So why don't you guys go talk and figure it out? Well, I'm thrilled because this was exactly the plan the whole time. Opposing counsel is not so thrilled because I essentially am getting exactly what I want. And so we go out in the hall and I say, look, this clearly isn't going your way. Why don't we just settle and we'll do reasonable child support for mom because dad makes so much more. And we'll waive all this other stuff and mom will provide the insurance and dad can help contribute to that. And we'll just go from there. And she goes back, and we went back and forth with her client several times. And I can, we're separated, and I'm kind of out in the hall, and she's in this side room with dad. And I can hear, I don't know what they're saying. I just hear dad yelling, right? I just hired you, blah, 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 blah. You're supposed to win. You're the bulldog. And now we're not winning. And so she finally comes out and she says, look, I'll give you this much in child support, but that's it. And I said, look, I don't believe that that's what dad makes. So what we ended up doing was we came up with a deal where we agreed on a particular amount of child support, but because dad was playing games with his income, I got them to agree to provide me with his income statements at the end of the year so we know exactly what he's making, whether that's 1099 or whether that's a W-2 type income. And then we'll waive all the other financials. And the other attorney comes back and says, well, dad says he'll do that, but he still wants mom to pay all of his attorney fees. So I said, look, I don't think it's going to fly, but if you want, you go ahead and talk to the judge about that. So we go back in, we put our deal on the record, and the other attorney gets up and says, okay, here's our deal, here's the timeshare, here's the child support, here's what we're going to do. And judge, by the way, because I had to go through all this trouble, I'd like to ask the court for my attorney fees. The end. Thank you, Judge. Judge looks at me and says, Mr. Smith, what would you like to do? And I said, Judge, I agree with opposing counsel. We came up with a wonderful deal. This is what's going to save the court a lot of time. This is going to save the parties a lot of money. Mom's agreed to waive everything. And in fact, what mom would like, Your Honor, is a clean slate. She'd like nothing more than just to go on with her life and not have to worry about any of these arrears like you talked about. You didn't want to see any of that. But I suppose because opposing counsel is going to ask for attorney fees, now I have to ask for attorney fees. So if they're going to do it, I guess we'll do it. I wish we didn't have to. And the judge kind of snickers and is like, well, if you guys both want to do that, you go ahead and we'll see what happens. And so that's what happened. And bottom line is we took a case where mom was destined to lose, flipped it around, flipped the script on the judge, used the laws that are here in the state of Nevada in our favor, and got mom everything she wanted within just a couple of weeks, when prior to our coming into the case, she had essentially dug herself into a hole she didn't know how to get out of. Look, these kind of things happen. If you do need legal representation, family law type things, divorce, custody, adoption, please feel free to give us a call at the office, Smith Legal Group, 702-410-5001. And until then, we will see you next time on The Legal Smith Unleashed. Don't forget to like, share, subscribe, thumbs up, heart, and tell all your friends so that we can keep doing these fun little podcasts and showing you the ropes on how to win your case here in Las Vegas. We'll see you next time.